we are Legally Sis. Welcome to our podcast.
The information provided in the show is for general informational purposes only and should not be construed as legal advice on any subject matter. No attorney-client relationship is created between you and Donee and Donor Jules Law.
Hi, welcome to Legally Sis. I'm Attorney Wen.
And I'm Attorney March. Welcome to our podcast. In this episode, we will be discussing about donation.
So, Attorney March, let's first define what is a donation.
Donation is an act of liberality whereby one person gratuitously gives or disposes a property or a right in favor of another person who accepts it.
Okay, so when you say property, what are those?
It can be anything under the commerce of man, meaning anything that you can own, hold. It can be tangible, it can be non-tangible.
Okay, so in the process of donation, there are two peoples who are involved. So it's the donee and the donor. So let's define what is a donor and a donee.
Right, a donor is the person that gives the property liberally, gratuitously. The donee is the person that receives it and has accepted the donation from the donor.
Okay. Are there any formalities with respect to giving something to another person?
Yes, but it depends on a number of things. Okay, one, if it's an immovable property, meaning it's bolted to the ground, like a real estate land or a building improvement, since it's something that you cannot move from the land because it's bolted there, then you need a formality. It has to be in writing and it has to be in a public instrument because you'll need it anyways with the registry of deeds or the city assessor and treasurer to have it transferred under the donee's name. If it's a movable property, it's a jewelry, it's a shares of stock, it's anything of value. If it is more than 5,000 pesos and above, it has to be in public or private instrument. But there is a difference there. So if it's 5,000 pesos and above, and it is given simultaneously upon the donation, then it can be in public or private document. But if it's 5,000 pesos and above, but it is not given to you immediately, for example, it would be given to you the next year, 10 years from now. So there's no simultaneous delivery of the property being donated to you, then this has to be accepted in writing also by the donee.
You mean it's conditional donation?
Correct. If it's anything lower than 5,000 pesos, then it can be verbal. It doesn't have to be in writing.
Okay. So who can be donees?
Any person, whether natural or juridical. So I would say natural because that's an individual, me, you, your child, your aunt, your uncle, your mom, your dad, your grandchildren. But if it's a minor, then you will need a guardian or you will need someone that would act for in behalf of the minor. It can be a corporation, that is the juridical person. But when you are a donee for in behalf of a corporation, you have to act via a board resolution. So there are different types of corporations. You have a government corporation, you have a private corporation, you have an NGO, you have a one-person corporation. So long as you are authorized to act for in behalf of the corporation to accept the donation, because as I explained earlier, acceptance is necessary, then yes, you can also be a donee.
All right, so going to the formalities of a donation, say a property which is over 5,000 pesos, does it need to be in a form like the terms and conditions, has to be notarized?
If it is real estate property that is being donated, it always has to be in public document or notarized. Otherwise, it will not be enforceable. If it is a movable property, then it has to be in private or public document. So it's not really clear under the civil code if it always has to be notarized, but I would say err in the side of caution and just have everything notarized so there won't be any question.
Okay, so let's say there's a document wherein the donor and the donee has prepared. So what are the usual or the common provisions that you will see in such donation agreement?
First of all, the parties. They have to be indicated there. You have to describe the parties. Who is the donor and who is the donee? Their name, marital status, their office address or residential address. If it is a corporation, then who is the representative of that corporation, whether as donee or as a donor. And then, of course, the object. What is being donated? Right? Is it a movable property? Is it a real estate property? If it's a real estate property, then you have to particularly describe it, like the technical description. Now, the Registry of Deeds is very strict that in any transfer documents of a real estate property, you have to indicate the metes and bounds of that particular property on top of indicating the title that identifies the property, the CCT or the TCT number or the OCT. And then if you have other conditions, like if it's a conditional donation, you're going to get it only after a certain number of years, or even if you give it now, but you can't use it for commercial purposes, or you cannot partition it, or you cannot sell it to another person, specifically XYZ, or any other condition that the donor may want to impose upon the donation, that's also possible. But if you do have that, it has to be indicated in the deed of donation. And of course, the acceptance of the donee. Acceptance of the donee is very necessary, otherwise it's incomplete.
Right. Does it needs to be in the same document that the acceptance of the donee be mentioned there, or could it be in a separate?
It can be in a separate document. It's cheaper if you do it in one document because you're going to show up with the notary public anyway, and it would be just one document and one payment for the notary. But if and in case you are not in one location or it has not been simultaneously delivered to you, then it can be in another document saying that you are accepting the donation.
Right. So, are there any tax implications whenever you donate something?
Oh yes, donation has a tax of 6%, just like sale, which is also 6%.
How about personal properties?
As to the taxes, there is this first 250 exemption. So if the value of the property being donated is 250,000 pesos and below, then there is no donor's tax. But if it will be over that, then you have to pay the 6% tax from the time the effectivity of the train law, which is more or less 2018.
Can a person give something that he does not own?
Of course not. You cannot give away something you do not own.
Yeah, because there are situations wherein an heir or a potential heir is already donating or getting something from their parents, but their parents are still alive.
Correct. Correct. That's not possible. The parents would have to die first before you can get an inchoate right as to their properties. I would also like to emphasize that you cannot donate something that will go over and beyond what you can give in a will. Because eventually, if you do that, it will affect the inheritance of the forced heir of that donor. I would say there would be instances wherein, while the donor is alive, that donor would give everything to child one. But there really is two children. So if the donor is allowed to donate everything to child one, then nothing will be left to child two. That is not allowed. So the child two can question the donation.
So you mean there's restrictions or limitations?
Yes, there would be a limitation. Because at the time of death, the heir would have the right to collate and check if the assets of the donor or now the deceased has been properly distributed among the forced heirs.
Now we go to revocation. So what are the usual grounds in order for a donation be revoked or canceled?
Okay, canceling a donation requires really strong grounds. Okay, number one, the donor did not really have the capacity to donate. There's fraud, there's intimidation, there's duress. Number two, the donor did not really intend to donate the property. So there's no donative intent. If that's the case, then the donation can be revoked. We mentioned about the limitation a while ago. When it is way more than what he can give as a will, then the court will reduce it or abate it so that the heir's inheritance or legitim can be protected. There is also the situation wherein the donee committed a crime against the donor, against the honor or the person of the donor, his spouse, or his immediate family. So, for example, donation has already happened, but you tried to kill the donor, then the donor can revoke the donation. It's also necessary for the donee to comply with the conditions of the donation. So if there are restrictions on the donation and the donee disregarded it, and it can be a ground for the revocation of the donation.
Alright.
This is very difficult because sometimes the condition can be years after the time of donation. It can be 10 years, 20 years, 30 years. Known family in the US would donate a huge amount of money to build a building, provided the building will be forever under the name of that family that donated it. And then, there are instances wherein the school would want to change the name of the building. So if the family of that donor, as you trace it back, right, can question the change of the name of the building because it's stated in the donation. Donation can also be revoked by reason of ingratitude. So if there is an obligation of the donee to give support to the donor, for example, it's a mom donating to the child, right? Everything owned by the mom is already given to the child with, the mom expects the child to take care of the mom, but eventually the child refuses to support the mother after the mother has given away everything that she had to the child, then it can be a cause of revocation of the donation. It must also be emphasized that the donor has to essentially leave something for himself. And it helps if you state that in the deed of donation, stating that the donor has left something for his upkeep so that he won't be destitute when he has donated his property. And lastly, the donation should not be done in contravention with your obligations. For example, there are a lot of creditors going after you. You cannot donate your property mainly because it would have been taken away by the creditors. Because if that happens and if that's proven, then the donor can collate, meaning have the donation revoked so that the obligation to them can be satisfied first before any donation is going to happen.
So are there any instances wherein a donation bid can be considered as a void in the beginning?
Yep. From the very beginning, there are instances where a donation can be considered void already. These are a donation between those that are guilty of adultery or concubinage, bawal kabet, right? Because it's against the law. So you can't profit from a criminal act. In the same way, if the donation is by reason of a consideration of a criminal offense, like you hired somebody to kill another person, and that donation is essentially a compensation of the act done. So that's not allowed. And third, donation to public officials or their family, because it's essentially a bribe. So those donations are considered void from the beginning. So if you are the aggrieved party, for example, in concubinage, you are the spouse, the legal spouse, you can file for the revocation of the donation between your husband and the kabit. If it would be adultery and then you have your husband complaining before the courts, canceling whatever your wife has given away or donated to another person. But if it's a crime, it's a criminal offense, a fruit of a criminal offense, then the government would be the one to file for the revocation of the donation. Donation, or the value of the donation, should be tied in with the inheritance or the supposed legitim of the heirs. There is a computation to that. And just wait for our episode, because that would only be the time that you'll realize or you understand if you are in the position to complain if what has been donated prior is something that will affect what you would have gotten as part of your legitim or your inheritance when any of your parents die.
Okay.
Thank you for listening. Bye.